Hello friends, Namaskaram. One of the person had sent a letter to me with specific query. My advocate cheated me. What I can do? Some says go to PS, lodge the FIR, and book him for cheating. Some says you cannot do anything because law is with lawyers. What I can do? So basically, if you feel that you are cheated, then you are the person who is bringing the prosecution. In that scenario, you have to pinpoint on your case. You have to show the violation of law, and you have to show that the facts available on the record inter alia attracts the ingredient of the offense. If the ingredients are not satisfied, the facts are general, omnibus, inconsistent, without any corroboration, you could not be succeeded. Now the important question arises how to prosecute the advocate in case the client feels that he is cheated. But now the important question arises in which manner a client could feel that he is cheated when advocate gives some promise. For example, we give certain promise to our child. In the evening, I will come and we will bring toy. And what do you do in the evening? You inter alia visit your house in the late hours. Finally, break the little heart of little master. And ultimately, he says, "It's okay, Papa. Let's see at another point of time." But client is not your child. If you do certain promise, if you make certain commitment, and the result is not favorable, he will say two important words. Your reputation is not good. I have inter alia observed the same from multiple people from the locality. He might threat that I will commit suicide and will involve you in multiple cases. So basically, we have to discuss the said topic from both perspectives. We have to observe this topic in the balance approach from client point of view, from advocate point of view, so that both could protect themselves from being harassed in the illegal way. Because there might be a possibility that client may inter alia harass or humiliate the advocate. And in the similar way, there's a possibility that the advocate is going to humiliate or harass the client. So basically, I have read one of the most important book of clinical psychology, in which the important concept is given, which is called the protection. Everyone needs the protection. And whenever we are in the safe hand, we feel that we are protected. Client needs protection of lawyer. Sir, I am having the legal trouble. Please protect me. Please help me. An advocate needs protection of client. Pay me so that I could save you. So whenever there is a breach of commitments, either from the side of client, for example, he engaged but never paid, and maybe on the part of advocate, he engaged but never gave services, then what to do? Basically, as far as law is concerned, it is not the criminal offense. These are not my words. These are words of Honorable Supreme Court. Judgment title is Chandra Shekhar versus Satish. Judgment date is 27th of March 2025. In that case, do you know? The advocate committed with the client. Client, listen my words carefully. Come, listen. I promise you that you will win. I'm going to assure you. And ultimately, you will get favorable result. Engage me. But finally, the client lost. Advocate defeated. Client was unhappy with the result. He inter alia communicated, but all in vain. And finally, he depressed. And he also attempted to commit suicide by consuming sleeping pills. So, who got panic? The client. And ultimately, who is the victim? The client, in your opinion. So, definitely, a criminal case must be on the advocate. So, in that case, also, a criminal case was registered against the advocate as per section 420, section 323, section 506, section 109 of IPC. But he was charge sheeted as per section 420 of IPC. Finally, the affair is quashed on ground that mere promise is not cheating. So if your advocate says to you, don't worry, I will have result favorable for you from the court of law, such promise would not constitute the breach of trust. It would not attract the offense of cheating in case it is broken. So now the important question arises, what we can do. First of all, I will discuss this topic from the point of client. You can do two important things. As per Bar Council rule, the concerned advocate is duty bound to specify the nature of engagement. So can we write a simple proposal on the paper? Is it possible for us or not? You are literate now, you may write now. Do only few things while writing the said proposal. Specify your name, specify the advocate name who will plead or draft your case. Specify the scope of work, whether he is engaged for drafting or for pleading or for per appearance. And apart from that, specify the total fee agreed. You have to specify that in case of any change, from what date the change would be applicable. In that scenario, we could protect ourselves from being cheated. And in addition to this, I request all of you, do not pay any money to advocate in cash. Always pay in accounts. Because in case he forget about certain receipt, you may recall him by showing him the receipt of bank, which is called bank statement. In that scenario, you could parry the scenario of being cheated. Now it is clear to you. And as far as advocate is concerned, do not try to speak to your client over phone. The reason being is that the ocular evidences are having no value. You are also supposed to mention your concern in the proposal as well. Even do not accept the fee in the cash. And apart from that, do not make any proposal or any promises that are casual. Just read the entire case. If you find that it is good, you may say that it is good to fight. But never say 100% you will win, 100% you will be succeeded, because guarantee inter alia may result in the professional misconduct. So these protocols are required to be observed either by advocate or by the client, so that both of them could be in the protective shell. In that scenario, both of them could minimize the chance of being cheated. So I think that I have provided you the valuable information on the subject. See you in the next video. Till then, Har Har Mahadev, Jai Shiv Shambhu.